Assalamualaikum warahmatullahi wabarakatuh. Good morning to all the honorable guest speakers and our moderator. The Honorable Profesor Dr. Haji Joni Emirzon S.H.M.Hum, as Dean of Faculty of Law Universitas Sriwijaya, the respected Dr. M. Syaifuddin S.H.M.Hum, as Vice Dean Academic Affairs of Law Universitas Sriwijaya, the respected all lecturers of Faculty of Law Universitas Sriwijaya, and all the participants that has gathered here today. The honorable speakers for today's International Public Lecture, Profesor Dr. Rashika Ahmad Khalid, as Dean Faculty of Law Universitas Kebangsaan Malaysia, and Sir Adrian Nugraha, S.H.M.H. PhD, as International Law Lecturer, Faculty of Law Universitas Sriwijaya. First of all, let us praise the mighty God for all of His blessing, so we can gather here in a good condition to participate in today's event, International Public Lecture, initiated and organized by Faculty of Law Universitas Sriwijaya as part of the Sriwijaya International Legal Excellence Program with the theme Green Law, the Global Impact in International Environmental Law. Let us start today's event by singing the national anthem, Indonesia Raya, and UNSRI's anthem, which will be led by Miss Salsa Bila Putri. To all the audience, you may please to stand up.
Ilmu alam pengabdian generasi baru yang penuh semangat untuk mengabdi, melati bunga yang suci, lambang agung keluhuran cipta, menghadap Tuhan yang esa, menuju masyarakat adil makmur.
Rabbana wala tahmil alaina isran kama hamaltahu alal ladzina min qablina. Rabbana wala tuhammilna ma la taqata lana bi. Wa'fu 'anna waghfir lana warhamna anta maulana fansurna 'alal qaumil kafirin. Rabbana atina fid dunya hasanah wa fil akhirati hasanah wa qina azabannar. Wa sallallahu ala sayyidina Muhammadin nabi ummi wa ala alihi wa sahbihi ajma'in. Subhana rabbika izzati amma yasifun wassalamun alal mursalin walhamdulillahi rabbil alamin. May Allah bless us. Thank you. Assalamualaikum warahmatullahi wabarakatuh.
The next agenda is welcoming speech by Dean of Faculty of Law Universitas Sriwijaya to Professor Dr. Haji Joni Emirzon S.H.M.Hum. The time is yours.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Selamat pagi, salam sejahtera bagi kita semua. Peace be upon us all. Salam, Om Swastiastu, Namo Buddhaya. Ladies and gentlemen, first of all, let us offer our gratitude for God Almighty for this His grace and blessing that allow us to gather here today, both in person and virtually, for this prestigious international seminar on green law, global impact in international environmental law. Allow me to extend my warm greeting to our distinguished speakers, Professor Dr. Rasika, MD Khalid. Good morning, Prof. Dean Faculty of Law, University Kebangsaan Malaysia. And then second, Adrian Bapak Adrian Nugraha S.A. M.Hum, PhD, International Law, Lecturer, Faculty of Law, Sriwijaya University. And all Vice Dean of the Faculty of Law, Universitas Sriwijaya, and the respective lecturer and academic staff, my student, from Sriwijaya University and Jambi, and others faculty. And then the organizing committee who have worked tirelessly to make this event a success, and of course all participants join us today, both physically and online. I'm honored to welcome to this international public lecture, a part of the University Sriwijaya International Legal Excellence, or SILE program, organized by the Faculty of Law, Sriwijaya University. Over the years, our faculty has constantly to be at forefront of legal education and research, both nationally and internationally. Today's seminar is a testament to that commitment, bringing together some of the most brilliant environmental law minds from around the world. The topic today is Green Law, Global Impact in International Environmental Law. Is especially timely and relevant, refer to the creation and implementation of legal standards that aim to safeguard the environment and on global scale. It emphasizes international collaboration through treaties, agreement, and regulation to address widespread environmental challenges such as climate change, pollution, deforestation, and biodiversity decline. The global influence of green law is reflected in the way a nation work together to tackle environmental issues that go beyond borders. Agreements like the Paris Agreement, Kyoto Protocol, and Convention on Biological Diversity encourage sustainable practice, establish accountability among countries, and start to protect the planet for future generation. I am convinced that this insight by our esteemed speaker today will enhance our understanding of environmental law perspective and inspire innovative solution to the complex legal challenges we face in today's rapidly evolving global landscape. Once again, thank you all your participation. I hope today's discussion will not only enrich our knowledge but also strengthen collaboration between our institutions, following the development of legal education and practice for better, more just society. Thank you so much for Bu Dekan, Prof. Rashidi MD Khalid, and Dr. Adrian Nugraha for your time this discussion today. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you, Professor Dr. Haji Joni Emirzon M.Hum for your welcoming speech. The next agenda is certificate presentation and photo group, which being made by accommodated by our respectful committee. The first certificate is to Sir Adila Nugraha S.H.M.H. PhD will be given by Professor Dr. Haji Joni Emirzon S.H.M.Hum. And the next certificate is to Ms. Resita Ziljianda S.H.M.H. as the moderator today will be given by Dr. and Syaifuddin S.H.M.H. And a certificate to Profesor Dr. Rashika Mathalid at Dian Faculty of Law, University Kebangsaan Malaysia. And to the Honorable Dean Faculty of Law, Universitas Sriwijaya, and all the lecturers to join the group photo in front. We continue our agenda by opening session for seminar by our moderator, Ms. Resita Ziljianda S.H.M.H. She graduated from UIN Raden Intan Lampung and graduated Master of Law in Lampung University. She has achievements such as the Best Graduate Student of Law Master 2023, the Best Graduate Student of Law Bachelor 2019, the second winner of Constitutional Debate on Empire RI 2017, and the Debate Delegation of Constitutional Court on Mahkamah Konstitusi 2018. Please welcome our moderator today, Ms. Resita Ziljianda S.H.M.H. To Ms. Resita, the time is yours.
Alright, Assalamualaikum warahmatullahi wabarakatuh. Alright, ladies and gentlemen, good morning for this agenda today. So today we have an international public lecture that we have the theme about environmental law. So before we have a short explanation about environmental law, so let me explain it. That environmental law refers to short set of layer rules and regulation created to shield the environment from the negative impacts of human action. It addresses first critical areas including pollution of air and water, waste disposal, wildlife conservation, forest protection, and the issue of the climate change. This branch of law plays a vital role in preserving the earth by providing a clear and organized legal framework that not only prevents environmental law, but also supports sustainable development. And it serves as both a protective barrier and guiding force, helping to safeguard natural ecosystem while directing human behavior toward environmentally responsible practices. Alright, ladies and gentlemen, I am Resita Ziljianda as a moderator today with our international public lecture team, Green Law, Global Impact in International Environmental Law. Alright, ladies and gentlemen, before we started our agenda today, we just inviting our distinguished speakers that we have Professor Dr. Rashika MD Khalid from University Kebangsaan Malaysia and Sir Adrian Nugraha S.H.M. PhD from Universitas Sriwijaya. Alright, ladies and gentlemen, our speakers represent with us right now. This morning, joined via Zoom and in person with us right now. So let's move on with the first speaker. Our first speaker is from University Kebangsaan Malaysia. Okay, she is a dean from Fakulti Undang-Undang University Kebangsaan Malaysia. She is Mrs. Rashika M. Khalid, is an associate professor at the Faculty of Law of UKM, University Kebangsaan Malaysia, and associate fellow of Fuel Cell Institute UKM. She obtained her PhD from UKM, Master of Law or LL.M. from University Malaysia, and her Bachelor of Law LLB from the University of Sheffield, United Kingdom in 2012. She completed 3 postgraduate courses in Building Resilience to Climate Change or BRCC from the United Nations University or UNU, Tokyo, and was appointed as a teaching assistant for the Upland BRCC courses in UKM. She was a visiting researcher at the UNESCO Centre for Water Law, Policy and Science at the University of Dundee, Scotland. She is a board member of the International Sustainable Development Research Society ISDRS. Her research includes environmental law, energy law, climate change, and development law. Alright, ladies and gentlemen, please welcome our first speaker and an amazing speaker, Professor Dr. Rashika MD Khalid. Alright, Professor, good morning. Time is yours.
Assalamualaikum warahmatullahi wabarakatuh.
Sorry, Professor.
Can you
Oh
hear
yeah,
me?
we can't hear you. We cannot hear you.
Hold on. Can you hear me now?
It's still mute, I think.
Hold on.
Okay. Our Professor.
I will try this.
Oh yes, yeah. We can hear you right now. Right? Yeah. We can hear you right now. Okay, time is your Professor.
Good morning, everyone. Especially Professor Dr. Joni, Universitas Sriwijaya. Thank you for inviting me. And also, good morning to Miss Rasita as our moderator today, and also Dr. Adrian as my second speaker. So I was given this topic on the environmental justice in international law, a Malaysian legal perspective, and now I will just switch my. Hold on. Can you see? Right.
Alright, Prof.
Okay, you can hear me and see my screen, yeah?
Yeah, we can see your presentation and PowerPoint in here.
Thank you. So, I'm going to talk about environmental justice and what is justice under the Environmental Protection Agency of United States. They have actually discussed about this, and in 2019, they relate environmental justice as fair treatment and meaningful involvement of all people, regardless of race, color, national origin, or income, back to the development, implementation, and enforcement of environmental laws, regulation, and so essentially, environmental justice is means treating everybody, any people from all backgrounds, when it comes to environmental policies. And of the justice is to ensure equal distribution of clean air, water, green spaces, safe housing, and environment. So what is aimed to achieve to ensure that everybody have the same access to clean water and natural resources. Environmental justice can also that affected community have a voice and influence in emergency planning and enforcement. Because what we see now, development process are only concerned about effect. They're to the developers without actually the affected community. Whether the development is to bring good to environmental justice prevent disproportionate exposure, pollution, climate risk, degradation for the marginalized and vulnerable communities. So what environmental justice do is to acknowledge the right, the values, and the knowledge system of certain groups of people, especially indigenous people, racial minorities, and low-income communities. So there are several components of environmental justice. One, and they are all concerned with certain rights. And we know that under the notion of justice, we have substantive rights, we have procedural rights, distributed justice, and recognition. So when we talk about justice, we want people a right to healthy, clean air, clean, and lots of green spaces. So that is something for each and every individual. We are also concerned about procedural rights. We want to know whether everyone have access to information, and with that information, you can have effective participation and meaningful decision-making process. And is embedded individual, you will have access to justice. And for right and procedural right, notion of justice also requires distributive justice, i.e., of environmental benefits and burdens. And in total, what environmental justice do to acknowledge the right of marginalized, the poor, okay, the vulnerable. Okay, so those are the components of environmental justice. But how to implement environmental justice? Under the international law, we need that will enforce, implement these rights and justice. So for substantive rights, laws that require equitable access to environment amenities like clean air, water, and green spaces. So we talk about right to clean environment. There must be a law or some statement of legal requirement that on that purpose. For procedural rights, we need all people, regardless of race, ethnicity, or income, to be treated equally in the environmental process. And for distributive justice, we need certain laws that prohibit disproportionate burden, hazard on vulnerable communities. And the law must also recognize and advocate for environmental policy in all segments of communities, and it cannot just, give benefit for the or certain groups of people. See injustice in many places around the world, and one of the environmental injustice is of pollution. So why pollution cause environmental injustice? Because rights. There are certain communities, certain segment of the communities, especially they are often environmental pollution. So events around the world, Asia, Indonesia, or we know the poor. Sometimes they are very exposed to certain pollution. You're right. These people, they don't have access accurate and transparent information on environmental risk and air quality that they live in. So we often see factories develop around this area, the slum area, and the people there has no voice to say, you can't do this, you can't do that. So they do access to information before the place. Distributive concern about their scarcity of economic resources and access to political that limits their ability to demand environmental quality. So they don't have to say to the government, we want better environment for us to live in. And injustice occurs when their voices are in the development process, and it continues until we have, one or two environmental them, one or two NGOs that come and be the voice, on behalf of these people. So that is something that, continues to be unjust and disproportionate to these people. So mainstream environmental justice in international law, there are three principles, important principles that must be there, the justice in the law: equity, two, fairness, and three, human rights. So these three principles need to be integrated in a governance framework. With equitable policies, the legislature must consider both the people and also within. The policymakers must ask whether the pollution will affect a particular area and how will it impact the people, the public health in that area. The consideration made the government's new urban areas or the government license and new mining activities. Okay. Sorry, I was asked to start my video. I just switch it off because I don't want to interrupt with the internet connection. Okay. But I hope you slide. Please let me know if my voice or my slide is not moving. To ensure these are there in the environmental governance framework, policymakers, the government must ask whether there are long-term environmental damage which will impact the human, the ecosystem, or endangered species. So these are the questions that policymakers must consider when they want to ensure environmental in international law. Okay. Is my slide moving?
So sorry, Professor, that your presentation is not move on. Is it moving?
One moment. Can you see on fairness?
Yes, yeah. We can see the fairness. All right. Thank you, Professor.
The second principle mainstream environmental justice in international law is through the principle of fairness. It's important because fairness, environmental governance is effective, legitimate, and also inclusive. And fairness will strengthen the diplomacy of global decision-making process. And when we fairness, when we want to develop international law that means incorporate environmental justice, will reduce the risk of conflict before they escalate. So before any develops, the government must ensure that the countries that live surrounding the area are consulted and has been briefed properly about the fairness will also the principle of common but differentiated responsibilities in and environmental law. So common but differentiated responsibilities concern about the different role that international community can in environmental law. Because we know that developed countries, they are the one who polluted environmental damage when they developed time ago, decades ago. But we developing countries, we want to develop and we are also using the natural resources. So to be fair to us, the developed countries must helping us to develop cleaner technology and develop in a better, in a lower risk. Okay. I'm sorry.
Alright, Professor, is there any problem?
My slide is moving here.
Oh, cannot moving.
Yeah.
Alright. Or that's okay, just like in the small say size, that's okay, Professor. It's not only just like in the full size. Oh yeah. Alright, Professor. So sorry if the presentation or the PowerPoint it is like with us, not just like the slide with just with us, not you show the PowerPoint. Professor. Professor. Hello, Professor. Do you still with me? Professor?
Okay, no.
Okay.
I'm sorry.
Oh, yeah. Alright, Professor. The PowerPoint is like a slide with us. That's okay. It's with our with our committee. You can continue your presentation.
Yes. So I'm sorry about that. The time happened on online seminar.
It's okay, Professor.
Can you move to the next slide? Right, thank you. So, the third principles that we must consider to mainstream environmental justice in international law is to the principle of human rights. So, when we have human rights law, the human right laws can offer clear obligation for state legal avenues to redress, provides a universal legal and moral guarantees dignity and safety. Human rights can also emphasize non-discrimination and ensures disproportionately harm society. Human rights will also support participatory, transparent, and accountable governance. So, human right basically we ensure environmental justice, and it incorporated in the United Nations Sustainable Development Goals, SDG number 10, equalities, and also SDG number 16 on peace, justice, and strong institution. So when we have human rights, we can ensure environmental justice. All right. Next slide, please. So integration justice is already there. Mentions the United Nations framework on change and also the Paris Agreement. What the international community says inside the treaties is to ensure climate finance mechanism, prioritize the vulnerable population, vulnerable nations. So this is where the common but differentiated principle comes in, and we provide enough funding for countries to combat the climate change impact. Convention on Biodiversity also recognize the indigenous right and their traditional knowledge in terms of environmental protection. The United Nations Convention to Combat Desertification will land degradation and promote participatory approaches and equity in land use and restoration efforts. There are also human rights treaties that talks about, it doesn't actually talks about environmental justice, but it ensures certain rights like the International on Political Rights, International Convention on Economic, Society and Cultural Rights. When you have this right, then you can actually voice up against environment. And region like European Union have actually come up with convention like convention that provide access to environmental data, participation in decision-making process. So there are already convention, international law that have incorporated environmental justice into their treaties. Next slide, please. Besides these treaties, we need more binding treaties or protocol and environmental justice. This is just to make sure that developing countries can get redress for affected communities when they want to develop. Future treaties must accountability for transboundary environmental harm, especially and to recognize environmental defenders' right, and treaties must ensure free flow of on environmental harm, because data is very important, especially when the activities at the moment they don't cause much harm, but they will have long-term effect. Communities must have access to the data so they can be prepared and also to voice up their concern. Ease of protocol environmental justice can promote open access platforms for communities to report environmental harm. And this protocol will require civil society or independent experts to monitor the progress of the development so that it will not as the poor or certain communities. Next slide. So I just want to take another European law on water framework directive where it really ensures public participation through legal obligation. So member state will involve parts of the community, stakeholders, the public in water management. What the framework directive effective participation. So just by participation alone enough, it has to be effective to achieve good ecological status for all European Union waters, remakes and all that. So guidance document number 8 of the Water Framework Directive emphasizes that participation in relation to the directive requires active participation beyond informing enough that the government just inform what they want to do, just consulting the public, but they want genuine involvement in decision and genuine involvement. Everyone is at the same par, is at the same level. They don't actually concern about colors or race or religion, have the same position to speak out and give opinion on the development that will impact the world. So countries like Netherlands provide active stakeholder platform in their basin management. Countries like Germany provide broad consultation using digital tools and public. And countries like Spain develop local water board with many interest groups. By having this voice, then the public realize the participating process in their country, and they also realize their role that they can play. Government, they can protect a better environment. Next slide. So when we talk about it, we want to see what laws are there to actually ensure environmental justice. From the Malaysian perspective, we do have several provisions in the constitution to become our fundamental liberty, something that all Malaysians have the right to. It started from Article 5 to 13. 5 talks about right to life, prohibition against slavery or forced. Article 7 on prohibition against retrospective criminal double jeopardy. Article 8 on equality. Then freedom of movement. Article 10, freedom of speech, assembly, association. Article 11 talks about freedom of religion. Article 12, right to education, and Article property. So these are the from the surface. There's no particular statement on right to clean environment, okay, or ensuring environmental justice. This is 1957. Next slide. Article 5, 1, the wording of the article is that no person shall be deprived of his life or personal liberty save in accordance with law. So the question is, what is life? And what does life means? What does life consist of? And how and when the life is deprived? One particular case that talks about or elaborate this question, Tan Teck Seng case against Ranjaya Perkhidmatan Pendidikan. In that case, Justice Gopal Sriram says that the expression life appearing in Article 5 the existent, it incorporates all those facets that are integral part of life itself and those matters which go to form the quality of life. So life is not just being alive, but there must be other things that support that life. It includes the right to seek and full and gainful employment, the right to receive those benefits, and also include the right to live in a reasonable and pollution-free environment. So we don't that particular provision in our constitution on clean environment, but this case actually explain that life means quality life, including a quality environment. Next slide, please. But sadly, when we have, although we have one case talking about Malaysia to get cases about polluted rivers, we still have one. And the most striking one happened a few years back when we have one river in Johor get polluted badly, and it causes poisonous gases, and as a result, many people get sick. So this cause injustice because they live next to factories which pollutes the water. The river here has been cleared. It's good now, but we don't want this to happen again in the future. Next slide. Pollution will continue. What the affected communities can do is because in Malaysia need a local standby to bring a case to the court, and besides that, we certain groups, certain industries that continues to pollute because a way to dispose their so this has causes problem. So for communities, this will continue unless and until we incorporate clearly the right to clean environment or sustainable development in our constitution. So next slide. The constitutional right on environmental justice. We must ensure substantive rights are embedded. So we clearly stated that the environment into a national framework, which is our constitution. We must ensure that in that provision, it ensures the state is legal to protect, respect, and fulfill the right to environmental right. The provision in the constitution must require environmental benefits and burden to be shared equally, and the constitutional right should ensure that any individual can seek their right to clean environment. So if we have this kind of provision in our constitution, then we can ensure that regardless of race, religion, rich or poor, can bring and ask legal remedies from the court because it is their constitutional right. Next. So I just bring some examples how this constitution right has been drafted, used, implemented in certain countries. So the constitution of the Swiss Confederation, for instance, under Article 3, stated that the confederation and shall try to achieve a balanced relationship between nature, its capacity to renew itself. It basically means that just take up all the resources. We must make sure that if we cut down one timber in the forest, then we cannot just cut down 10 together, because we want the trees to renew and develop and becomes uh, a new tree after that. Article 74, for instance, talks about the Confederation shall legislate on the protection of population and its natural environment against damage or nuisance. And Article 76, the Confederation shall ensure economic use and protection of water resources and provide protections against harmful effect of water. So we have this kind in the Swiss Confederation Constitution that allows that requires government to take proactive steps in clean environment. Next slide. Two provision which I want to like how detailed they are in terms of ensuring clean water. So Article 76(2), the lay down principles on conservation and exploitation of water and other measures affecting water cycle, and on water protection, ensure appropriate residual flow, hydro and safety of the dams, and on measures that influence precipitation. To that detail in ensuring hydrological cycles are protected. Another country, next slide. Next slide, please. I also take Thailand as example because certain words there are very good in terms of benchmarking for Malaysia. So at Part 8, Section requires the state to follow land use environmental policy on land use applicable to the entire country with due regard to compatibility condition including land and water, and to undertake a fair distribution of land holding, including procurement of water sources for the adequate and use of water by farmers in agriculture. So they put on water for food and ensure that if we don't have enough water, then the farmers will first get, so that the agriculture, the food security continues to be there. Next slide, please. And Section 85 continues to say that the government must provide town and country planning and to implement effectively, efficiently for the benefit of sustainable preservation of natural resources. The government must also provide a systematic management plan for water and other resources for the community. So this actually incorporate environmental justice. Everyone has the right and interest in improvement of natural resources. The government must promote, conserve, and protect the environment under sustainable principle. So I would say that Thailand constitution a lot of things to ensure environmental justice. Next slide. India has amended their constitution in 2019. So Article 48A did to protect and improve the environment and safeguard the forest and wildlife in the country. And Article 51 requires the state impose the duty of every citizens of India to protect and improve the natural environment, including forests, lakes, rivers, and to have compassion for living creatures. So this means that the job to clean environment is the job of everybody, not government alone. Next slide. Another country that I compare is Philippines. Two articles important to environmental justice is Article 15, the right to health, and Article 16, the state shall protect and advance the right of the people to a balanced and healthful ecology in accordance with rhythm and harmony of nature. Article 16 for me is like a but what it requires is we must live with nature, make sure that our activities balance with the needs of, and with on 16 there was a case for the right this right under article where in Aposa the minor sued on behalf his and succeeding generation for ecology under the article. Next slide. So the court actually agrees and helps the environment, has a clear duty to protect and advance the right, and should cease from accepting and improving new timber license. And the court say, the court say this basic right need not be written even because it already assumed to exist of humankind. Because it's well-founded fear, unless the right to a balanced and healthful ecology are mandated as state policies by the Constitution, thereby highlighting their continuing importance and imposing a state to solemn obligation to preserve and protect. Okay, the second. So this case basically any government when they make decision, they should not only concern about the but also for the future generation. So whether if we continues to give timber license, our future generation may not get forests to live in the future. Next slide. Coming towards the end, I just want to highlight if we want human rights to be incorporated, we do have countries human rights to other nature, such as New Zealand. Kanu River in New Zealand was granted the same legal right as human being in 2000 because the people, the native of Wanganu River says that we cannot, the river is polluted. We need the river because it's part of our life. So they have fight for this for almost 100 years. And in 2017, it gave human right to the river, the status as a human to the river. So can sue or be sued, and that can be done by if. So I think we're coming to the final slide. Next slide. So what we can do to ensure environmental justice is to incorporate that right into the constitution. So for Malaysia, for instance, fundamental liberties, you don't have the local standard attribute in the court against polluters and all that. So by having that in the constitution, you can definitely ask for compensation, and then you can achieve environmental justice. So that's it for me.
All right, thank you so much for the amazing presentation from Professor Dr. Rashika M. Alip. Okay, give applause for Professor Dr. Rashika M. Alip.
Thank you.
All right, Professor. Professor, that I wanna say sorry for the mistake that I said associate from the first when I said your CV.
No.
Yeah, I'm so sorry about it. All right, Professor?
Yes, yes, okay.
Oh yeah, I'm so sorry about it, Professor, that I said associate from your CV.
That's okay.
All right, thank you so much, Professor. So before we continue our next agenda, let me give you some short conclusion with our the presentation before. The transition shifting from fossil fuel to cleaner transition this is one of causes raises concern about whether the move to low carbon and then economy is more inclusive for all parties involved. It is essential to ensure that the rights and well-being of worker and commodities reliant on the fossil fuel sector are not overlooked. The transition must also address existing social and environmental injustice linked to the fossil fuel industry, such as pollution, adverse health effect, and displacement of vulnerable population. A comprehensive assessment of the just transition is necessary to safeguard the fundamental rights of all stakeholders involved in the path toward decarbonization. And then the Federal Constitution of Malaysia should be amended to include the right to clean environment as a fundamental right. It will be achieved environmental justice. Alright, thank you so much for the amazing presentation from Professor Dr. Rashika. So let's move on to the next speaker that we have another amazing speaker too. The second speaker is Assistant Professor for Faculty of Law, Universitas Sriwijaya. He has specialization on law of the sea, Indonesian maritime law, international law, law of contract, environmental law, international economic and trade law, and he took his PhD on Institute of the Law of the Sea, National Taiwan Ocean University, Taiwan 2017 until 2021, with law science or law of the sea major. He has so many research projects, and one of the current research projects is protection and governance of Indonesian marine mammals in dealing with climate change at 2022. And then he has many publications about ocean and the sea, and one of the publications published on environmental policy and law with the title Progress, the legal framework issue in the establishment and control of Indonesian marine protected area. Alright, ladies and gentlemen, please welcome Sir Adrian Nugraha, S.H.M.H. PhD. Time is yours.
Okay, good morning. Assalamualaikum warahmatullahi wabarakatuh. Thank you for very enthusiastic moderator. The Honorable Dean, Faculty of Law, Sriwijaya University, esteemed Vice Dean for the Academic Affairs, esteemed faculty members, and honored international speakers, Professor Rashika, the Dean of University Kebangsaan Malaysia, and all participants joining us in both person and online. It's a great privilege and pleasure for me to welcome you all to this important public lecture. And to save the time, I will directly to my presentation about marine pollution issues in Indonesia, a legal analysis from domestic and international perspective. Maybe I choose one of the important issue from the international environmental law issue because issue in marine it probably can impact another country, not only in Indonesian territory but also in another, maybe to another country. From the introduction, as we know, Indonesia is the biggest archipelagic country in the world because we have more than 17,000 islands, and also we are considered as ocean nations, and also and some of scholars says that Indonesia is a maritime state because most of our territory or Indonesian territory is waters. We have comparing like a 2 to 3, like a 3 for waters and 2 for the land. That's why marine area is important to us to preserve. That's why this is I think this is an important issue for Indonesia, and also maybe for some country surrounding in Indonesia like Malaysia and then also Singapore. I tried to compiling several case from 2019 to 2023, like case in the Nias waters. There's a case asphalt leak from a tanker polluted in the North Nias waters. That is vessels that flying from Gabon, Africa. And also another case is a drilling error by Pertamina ONWG offshore Northwest Java in Karawang. And this incident already present troubling pattern where marine pollution continues despite existing international convention and also national regulation. And how to understand marine pollution. There is some of definition from national and international documents, law documents. Like from the Indonesian legal definition, like Act 32 2009 concerning environmental management and protection, that define that marine pollution, that entry of living things, energy substances, and another component into the environment or marine environment by human activity. So its quality drops to a certain level, causing the marine environment to no longer follow its quality standard and function. This is from Indonesian national laws from the Act 32 2009. They define about pollution. That what is pollution? This is the definition of pollution, like living things that entering ecosystem, that it cause the ecosystem is drop down, and then the quality standard is no longer follow quality standard and function. Also, international legal documents says under UNCLOS in the 1982 UN National Convention on the Law of the Sea, or UNCLOS, says that in Article 1 verse 4 says that the introduction by man directly or indirectly of substances or energy into the marine environment which results in such deleterious effects as harm to living resources and marine life. This international convention gave some of message to all their members that their participating states should be preserve and protect the water territory from the pollution. And then from the common cause, we know that marine pollution is commonly caused by ships, offshore drilling, and discharge of hazardous substances. Also, land-based pollution also contribute significantly, particularly from industrial activities that releasing heavy metals like mercury, selenium, and arsenic. So, from several definition, we can conclude that marine pollution mostly come from anthropocene activity or activity from human. It's like from ships, from offshore drilling, and another activity that cause destroying our ecosystem and ecology of our marine environment. Some of current case in Indonesia, like I mentioned before, First is in 2023 in North Nias, a Gabon flag tanker carrying more than 1,000 tons of asphalt leak into the sea that affecting waters marine conservation area. This is killing some of biota and impacting fishing and also tourism. This activity can this pollution disrupt economic surrounding society in near of Nias waters. And also in 2019 there is a case of marine pollution like Karawang oil spill. This is come from PT Pertamina Energy offshores that cause gas bubble and oil layer on the sea surface. And the spill can reach pitch 2 kilometers away, severely impacting local salt farmers. That is, we understand that this pollution can impact economic society surrounding this the shore area. And then in Bima Bay pollution. This is pollution from mineral mining, oil and gas industry, and also power plants has caused mass fish deaths and also affecting some of fishermen livelihood and also threatening biodiversity and also tourism. And also in Bintan, this is still continue in Bintan also. This is water oil or sludge oil from foreign ships polluted several areas in the area between Bintan and Riau Island, and the entire northern coast of Bintan with incidents occurring repeatedly of over a decade. This is I think this is pollution for more than 10 years. This is horrible. Also, it is a discussion from international legal framework. Maybe not only on UNCLOS, we also have like a Marpol convention from the IMO, but I want choose one of the convention that maybe you more common for some of audience, because this is I think Constitution of Oceans, United Nations Convention on the Law of the Sea 1982, that considering as a Constitution of Oceans. In this convention, they have some of international legal norm that focus on the marine environmental protection and also preservation. This convention calls all contracting members to protect their environment, particularly in marine environment. Then this convention also have a legal norm about liability framework. Every contracting parties must establish responsibility and compensation if their activity can pollute the marine area. Also, this convention has some legal norm about cooperation mandates. From Article 197 until 2001, this convention calls that every contracting state to collaborate to protect their marine area. So this convention give legal norm to all contracting parties to collaborate, not only personal state liability, but also for all contracting state to collaborate together to protect their marine area. Then also this convention have enforcement guidelines like in Article 2006 until 207 until 212 that giving guidelines to cover national law regulation that every contracting parties they must regulate about protection of marine environment. It can conclude that UNCLOS serve as the primary international legal instrument that addressing marine issues. It requires states to take all necessary measures to prevent, reduce, and control marine pollution from any sources, while providing a comprehensive framework for liability and also compensation. So how about in Indonesian response? Indonesia also ratified UNCLOS in 1985 with Act number 17 1985 about ratification of the UN Convention on the Law of the Sea. That's why Indonesia have an international legal responsibility to protect their marine environment. Also, Indonesia have some of national law like Act 1990 Act 6 1996 about territorial waters that govern use, management, and protection of the waters. And also Indonesia have Act about environmental protection through Act 32 2009 about environmental management and protection. Also in this act have an article that mandate state to push the liability, like a strike liability in Article 88 that establish absolute responsibility for polluters. Indonesia has developed legal framework for addressing marine pollution through several key laws like Environmental Protection and Management Law, Act 32 2009, and established that everyone is obliged to maintain the preservation of environmental functions and prevent and overcome environmental pollution and destruction. And this creates foundation for holding polluters accountable. And also we have some of principle regarding protection of marine environment is a polluter pay principle. This is principle from Act 32 2009 that says that from the prevention applied through environmental instrument like strategic environmental assessment, spatial planning, quality standard, and environmental impact analysis. Environmental impact analysis in Indonesia like AMDAL. You understand about AMDAL, right? And then mitigation. Polluters must overcome pollution by providing warning information, isolating pollution, stopping the source, and using other specific methods. That's this principle also have a enforcement like a provide for compensation, recovery actions, and specific measure to prevent recurrence of violation. Because this principle mandate that every environment need to recover, that require polluter to restore the environment through remediation, rehabilitation, and restoration following scientific developments. This principle is a backbone of Indonesians' environmental liability. This principle ensures that those who cause pollution bear the cost of managing it to prevent damage to human health or the environment. The implementation include instruments for prevention, control, recovery, and law enforcement. How about the mechanism for settlement disputes? Indonesia have some of instrument for or mechanism for a settlement dispute. First is from out of court resolution like mediation and also arbitration. It is mandated in Act 32 2009. Also, we have like a compensation claims that environmental agency can sue polluters for damages. Not only from out of court resolution, we also have like court proceeding, like a legal action when out of court settlement fail. That's it, you come to pengadilan to settlement the dispute if there is no settlement when you overcome with out of court resolution. Like in the North Nias asphalt spill case, this settlement involved environmental compensation and coastal recovery effort. Like for the Karawang oil spill, PT Pertamina Hulu Energy ONWG paid more than 18 billion rupiah because some of people affected. That this demonstrate that in how Indonesia legal framework can function when properly applied. The Act of Environmental Management and Protection allows that environmental protection agencies, this is like Kementerian Lingkungan Hidup dan Kehutanan or Dinas Lingkungan Hidup in province or in cities, to sue polluting companies for damages. Communities also file lawsuit with facilitating from the Ministry Environment and Forestry. We have a challenge in enforcement, like I mentioned before. Like we have problem in Bintan in Riau that more than 10 years of pollution and continuous pollution for the over decade without resolution. Some of major issues like in Lampung Bay, Semaka Bay, and West Coast of Lampung all suffer from ongoing oil pollution. Like in this is from Lampung cases, more than 18,000 barrel of oil transported from polluted Lampung waters in 2001 alone. 2021 alone. Despite the comprehensive legal framework, enforcement remain inconsistent because many pollution cases go unresolved or receive minimal attention. Disparity in handling marine pollution shows that law enforcement is often reactive rather than proactive, with action taken only after significant damage has occurred. But budget constraint further complicate enforcement effort, particularly for regional agency. Like in Bintan, for example, lack of allocated fund has hampered pollution resolution despite the problem persisting for over a decade. Then the conclusion, how to bridge the gap. First, we must strengthen the law enforcement. Like Indonesia must address the disparity in handling marine pollution case by ensuring consistent application of existing laws and regulations. So this is require political will and institutional capacity building. Second, we must apply strict liability consistently. The strict liability principle established in Act 32 2009 should be rigorously applied to all marine pollution cases, with compensation following the polluter pays principle. Then the third is a comprehensive approach that effective resolution of marine pollution requires addressing prevention, control, and recovery simultaneously, not just focusing on compensation after damage occurs. The contradiction between Indonesia's robust legal framework and reality of recurring marine pollution highlight a critical implementation gap that while the country has ratified international convention and established domestic laws, enforcement remains weak and also inconsistent. This is a problem for our country. We have some of laws. Also, we also ratified some of international legal documents, but the problem still like a weak law enforcement and inconsistent. For Indonesia to protect its very vast marine resources, it must move beyond paper regulations to consistent enforcement, adequate funding for environmental agency, and genuine commitment to the principle of environmental protection enshrined in its laws. Okay, thank you for your attention, and I will return this floor to the moderator. Thank you.
All right, give applause for our amazing speakers. All right, Indonesia needs to overcome inconsistency in addressing marine pollution cases by ensuring uniform enforcement of existing laws and regulation. Achieving this requires strong political will and institutional capacity and catchment. The strict liability principle outlined in Law Number 32 of 2009 must be firmly enforced in all marine pollution incidents, with compensation aligned to the polluter-pays principle. An effective approach to marine pollution must integrate prevention, control, and recovery avoid stimulation, rather than focusing solely on compensation after damage has occurred. To safeguard its extensive marine research, Indonesia must move beyond merely having regulation on paper and work towards consistent law enforcement, sufficient funding for environmental institutions, and a genuine commitment to the environmental protection principle embedded in its regulation. Alright, thank you so much, Sir Adrian, for the amazing presentation. Alright, so right now we have in the end of our session. Now we have a question and answer session, but before it, that I want to say hi with a student from University Kebangsaan Malaysia, just like join us in Zoom. Hi everyone. Alright, and then we have some student from Jambi University too. Alright everyone, hi. You can open your mic, that's okay. Alright, so for all of you, just like joining the Zoom, you can ask for some question with Professor Rasika and Sir Adrian too. But you can ask in the Zoom chat or maybe just like in the microphone, that's okay. But first of all, for all of the offline audience in here, that we have a 3 questions. So one of you, if you have asked the question, you can get 1 book for 1 person. If you can ask something with me, Professor Rashika and Sir Adrian. So before we started, that you have to raise your hand and set your name, and then what is your question, and then for who your question is. So please raise your hand and ask what do you want. Okay, please, everyone. Okay, right. Okay, yeah, stand up, please. Rosa, can you just like give the mic for her?
Okay, Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Thank you, Ms. Ray, for the opportunity. My name is Zafira Ida Pratiwi, as an international student major from Sriwijaya University. So I would ask Professor Rashika about climate change. So since the professor mentioned about Paris Agreement and the PPT, I will ask about it. So as we know that Paris Agreement regulate about climate change, but surprisingly, a few months ago, U.S. officially announced that they are out of the agreement. So as one of the parties of this agreement, how does Malaysia respond about the issue? And about the Indonesia too, what is the best response to respond the issue about Paris Agreement and about the America or US that out of this agreement. So thank you.
All right, thank you so much, Revi. All right. All right, thank you so much. Maybe just like we just langsung aja Pak. All right. All right, Sir Adrian, maybe first of all you can answer the question from all right, tadi Malaysia and Indonesia. All right. All right, Professor Rashika? Professor Rashika?
Yeah, thank you for the question.
Yes.
Yeah, regarding Paris Agreement, one thing that we must understand that under international, every country is sovereign on its own, and every country has the right to do whatever they want in their territory. And when America pulling out is part of the act of sovereignty, so we cannot actually impose on America, you know, you must stay in the Paris Agreement. It's an act of sovereign to whether to join to stop become a party to a certain convention. We as an international community, what we want is when we have international convention, everybody become parties to the convention. But when they don't want to, you know, commit themselves, then it will be a problem because everybody is working so hard to reduce the impact of climate change. But President, he don't believe in climate change, and he doesn't. He just want business as usual. So that will be a problem. What other countries can do is to continue negotiating and continue convincing him that climate change is real, and because carbon emitters must play as part of the international community. So we can't stop them from saying no, but international law, diplomacy is important. So our diplomats in United Nations headquarters continue negotiating and say that, you know, because America is we can't impose, you know, sanction or certain sanction and come back to Paris Agreement, but we can play a small part together. All countries says that America, you need to be part of Paris Agreement because, you know, contribute to the reduction in carbon emission. So now, but you know, as a United Nations members, and voice that out, and then get to come back to Paris Agreement. Thank you.
All right, thank you so much, Professor Rashika. All right, what about the answer, Rafia? All right, thank you so much, Professor. All right, for the next question, maybe it's from Zoom because I see a raised hand from Jambi University, from Mrs. Ari, right?
Yes.
All right. Oh, Dr. Ari, please.
Thank you very much to the moderator and to this opportunity. Two questions, one for Pak Adrian and the other for a professor. Sorry, Professor. I forgot the name.
Rashika.
Rashika. Yeah. To Professor Rashika. For the Pak Adrian, I'm not expert international environment law, but I interest it's talking liability in the marine pollution cases. As we know, in I'm sorry I forgot, but in the Undang PPLH number 32, the Environmental Law Act in Indonesian Environmental Act, we found article talking about liability. But the conflict in that article that find the strict liability cannot apply if found of the third party, such as what we the third party who make the pollution. So what about your opinion with this article? Because this conflict in this regulation we make the law enforcement, especially in marine pollution, very weak in Indonesia. So that's for Pak Adrian and Raskia. I'm really sorry, I'm not of international environmental law, but I just want to know about the Malaysian policy and regulation. While we know the health of environmental having the close relations with the life changes of the people. As in Japan, they having a good environment, and Japan it's popular with the have long life. I want to know the policy on Malaysia. How about to the human right of getting environment with of life, the long life like that. That's my question. Thank you.
Alright, thank you so much, Dr. Ari. So please, Sir Adrian, for answer the question from from Dr. Ari, please, and Professor Ashika.
Okay, maybe because of like internet signal, I think I tried to understand from Dr. Ari question that is state liability is difficult to implement in third parties, right? Is that the question? Okay, is if it about strict liability in the third parties, I think from the Act 32 2009 is they have like a principle. Is it called like a strict liability, or in Indonesia is pertanggungjawaban ketat, that every polluter should responsible in their action that cause of pollution. From this definition, I think every activities in Indonesian because this is a law national law. I think this is it's I think every polluter that is a foreign people or Indonesian nationality should responsible with their action with this principle. There is no need to prove there is it true or not, true or wrong in the court, but according this principle, according this strict liability principle, every people should responsibility with their action that cause and disturbing the ecosystem. It is also in several countries like United States or Canada. That is I think the first principle is comes from, I think I forget, but this principle it should be can implement it in Indonesia, particularly in marine environmental pollution. That I think this is maybe I think it's enough, right? Maybe you can move to another question.
Alright, thank you so much, Sir Adrian. Professor Ashika?
Yes, thank you for the question.
Yeah.
To compare Malaysia or Asian countries with Japan. Japan is a developed country, and what is important in Japan is that they emphasize on environmental awareness since children, since kindergarten. So they practice, they do it every day. They their own classes, and they develop good habits, and they develop this better environmental protection. And when in Japan commits to ensuring clean environment, then you have a better life and you live longer. In cities, in Kuala Lumpur, in Jakarta, any other cities where lots of industries, causes pollution, and lack of enforcement of punish the polluters. We usually see polluters get free. So, but in Japan, enforcement is very enforcement and to break law in Japan compared to us in ASEAN. So we have different cultures in terms of environmental awareness, and because of that, our government is more proactive to be more consistent in terms of enforcement. Everyone, obey the laws, and then enforcement is important. Then all we hope that all awareness increase for that, and then after that we will have better lifestyle and long life. So only about the law we require the law to be enforced properly, but it's also about the relation that we give to our kids. Maybe our grandfather, grandmother, during those days, they live in nature. So we don't live as our great-grandparents. We don't, bathe in the river. We cannot bathe in the river if the river is polluted, but now we just the water. So we never think about the cost. We don't see our river. And what the Malaysian government to have I mean, we don't want over at the backyard. We want facing. We are building up. We have the Kuala Lumpur. Everyone wants to face the river and see the river is polluted or not. So government is trying to do to increase our awareness about environmental protection. Thank you.
Alright, thank you so much, Professor Rashika. Okay, Dr. Ari. Enough. Alright, thank you so much. Alright, everyone. For offline and online audience, you can ask maybe just like one more question. Alright, please stand up. Giving the mic, please.
Thank you so much for both speakers for the very enlightening insight. I'm very grateful to have received all that insight coming from both speakers. Professor Rashika and Professor Adrian, my name is Adiba. I would like to ask a question that combine from the two topics that the speaker has already delivered to us. It will be about environmental justice and pollution. As we know, in 2006, there's a natural disaster or a drilling disaster called Sidoarjo Bootflow or Lumpur Lapindo. For now, it's still currently causing harm domestically to the surrounding residents, allocation, and sinking of all the houses nearby. But as we know right now, Sidoarjo Bootflow contributes to the biggest greenhouse gas that is going to be accelerating significantly for the global warming itself. So how does international law see those kind of problem where it's not yet causing direct harm into global or other nations, such as if we talk about marine pollution from earlier, if it's talking about oil leak in water surface, of course it can directly go to other country water territorial. But when we're talking about Lumpur Lapindo right now, it's still a domestic problem, but it's causing global harm later on with the rising rate of greenhouse gas, right? So how does exactly international law see those kind of problem, and how does it will contribute into ensuring environmental justice? Thank you.
All right, thank you so much for the question. All right, maybe Sir Adrian, you can answer the question from Adiba.
Okay, thanks. The question from Adiba is, I think I try to conclude this questions about role of international law to resolve pollution, right? To resolve marine pollution, right? The question. In the context of Indonesia, or maybe in other states, the first mechanism, maybe we can because this is issue about pollution in the sea, like marine pollution. If in context about marine pollution, the first measure, they can ratify some of international convention, and also consistency to doing enforce, like they should ratify like a UNCLOS or marine pollution convention under International Maritime Organization, and also applied in their national laws. Like Indonesia, we also have a ratification act like Undang-Undang 17 1985, and also we have like Act 32 2009 about Environmental Management and Protection Act. But I think the problem for like Indonesia is not in international in legal documents, but the problem is maybe some of issue in the legal in the national laws, but I think the most problem is in enforcement. The problem is enforcement. There is not inconsistent enforcement, corruption, and some of problems in enforcement. I think in our national laws, I think it's enough. If there is any some of defect in our national laws, it's normal. But the biggest problem for Indonesia is that the problem is from the enforcement. Because like Indonesia, we already ratified some of international document like United Nations Convention on the Law of the Sea, some and also several convention outside of UN convention, like from IMO, from International Maritime Organization, who also already ratified some of convention like Marpol Convention from IMO. Maybe this is my answer.
All right, thank you so much, Sir Adrian. What about Adiba? All right, enough. All right, everyone, for offline and online audience, we only one question left. So for everyone wanna ask something about environmental law, time is yours. Silakan. Do you have any question, guys? Maybe for online students. All right. Okay, Samila, please.
Okay, thank you. My name is Putri. I'm from International Law major. Indonesia has been identified as a major contributor to marine plastic pollution. Under international law, UNCLOS regulates state responsibility over marine pollution, but enforcement heavily depends on domestic mechanism. ASEAN lacks a binding regional legal framework in this domain. My question is, can the principle of the transboundary environmental harm in international law be used as a basis for lawsuits against ASEAN countries that fail to control marine pollution? If so, how can jurisdiction and international dispute resolution forums be effectively mobilized? This question from, I would like to Sir Adrian. Thank you.
All right, can you just like short your question? I mean, just like the main.
Okay. My question is, So the background is my question is Indonesia has been identified as a major contribution to marine plastic pollution. Under international law, UNCLOS regulates states' responsibility over marine pollution. Okay,
Short question.
ASEAN lacks a binding regional legal framework in this domain. My question, can the principle of transboundary environmental harm be invoked to hold ASEAN states accountable to marine pollution? If so, how can international jurisdiction and dispute resolution forums be effectively mobilized?
Okay, I tried to conclude this question because they're too long. I think it's about plastic pollution, right?
Yes, yes.
Because Indonesia, one of the I don't know it's the most pollutant in the seas. I don't know. Maybe yes. It's a role of our government to control this situation. How international or regional mechanism, how to regional mechanism to resolve this issue, right? I think the first thing that we must to do in Asian governance to do, we must we have UNCLOS say that we must doing collaboration with another countries, because our pollutant is come from Indonesia, maybe can pollute another country, another marine territory country, like to Malaysia or to Singapore, that we have boundaries, the maritime boundaries with the some of a country, right? That we must collaboration with some of country to the first things we can make like a bilateral or trilateral agreement or maybe regional agreement to stop issue about marine plastic pollution. This is the first thing we should to do. We must collaboration with some of several neighboring countries like Southeast Asian country like Malaysia, Singapore, and also in the northern of Sulawesi like Philippines, like UNCLOS said. The second is about how to enforce, how to make a strong enforcement. To give a penalty for the pollutant, like if the pollutant is come from our national territory, because we cannot implementing our international our national laws if like in high seas. But if it comes in our territory, we must doing strict law enforcement like that. Like I say in my presentation, we must consistent enforcement to doing this. It's from the international mechanism we must join, because we cannot. I think if the marine pollution is a different with like a pollution in the land. With marine pollution, we can spread. We cannot control the spread of the pollution. Maybe can spread on the high seas and or entering the waters other countries. So I think in like our government should make a collaboration like in like ASEAN countries, like Southeast Asian countries. We must initiative to protect to doing collaboration with other countries. So from international mechanism, from national mechanism, we must make sure our enforcement is most consistent. This is my answer.
All right, thank you so much, Sir Adrian, for the answer. All right, okay, give applause for our speakers, for Prof. Rashika and Sir Adrian Nugraha for the amazing presentation and the answer. So, ladies and gentlemen, right now we are in the end of session of our international public lecture. We have reached the end of the event. So, let me give you some maybe just a quote about this event, that environmental law is not just about protection, it is about justice, sustainability, and the right to livable world. I'm Vegitya as a moderator today. Say goodbye and thank you so much for your attention. Assalamualaikum warahmatullahi wabarakatuh. Sebentar. Ya, untuk yang tadi 3 orang tadi yang for the 3 participants who answer who question, jangan pulang dulu, we have to take a photo session ya for the 3 books. Thank you.
The last session concludes all of our agenda for today. We would like to say our biggest gratitude to all the honorable participants, speakers, and also our moderator. Our biggest hope is that all of you can get the valuable learnings from today's international public lectures. Lastly, I'm Rosa Indiana. Thank you for attention. Wassalamualaikum warahmatullahi wabarakatuh.
Kan 3 orang tadi untuk maju ke depan. We have to take a picture for your gift.